I think we're going to start. Welcome, everyone. And thank you for joining this Van Ameyde webinar, this webinar on cross-border claims. I'll be your host today. My name is Martine Morkes, and I work within Van Ameyde Group. Today, we look at a practical question. How does procedural law influence timing, cost, risk, and settlement strategy? We will focus on Spain and Germany and what their different procedural realities mean in practice. Before we start, this is the key idea. Jurisdiction is not only a legal detail, it can shape the entire claim strategy. It influences how quickly parties must act, how evidence is built, when costs rise, and when settlement becomes the smarter route. Today we will first set the context, and this is what we will cover. But briefly, in a nutshell, who we are and what we do. Van Ameyde Group brings together more than 35 companies across 30 countries, supported by a network of over 100 offices. That gives us a strong combination of local market insight, international skill, specialist expertise, and technology. For cross-border claims, that combination is essential. Complexity needs both local knowledge and coordinated control. I am very pleased to introduce today's speakers. Rianne van Heijst from Van Ameyde Spain will start with the Spanish procedural perspective. After that, Georg ten Brink from Van Ameyde Germany will share the German perspective. Together, they will explain how procedures affect claims handling, cost control, and settlement decisions. And with that, let's now dive into the content. Rianne, over to you.
Thank you, Martina. Hello, everybody. It's for me a very great pleasure to give you a little insight about the Spanish court proceedings. So my presentation today will be about how the legal framework for cross-border civil claims is in Spain. First of all, cross-border litigation in Spain is governed by a combination of national and European law. The core layers are the Spanish Civil Procedure Act and the EU regulations. Those would be Brussels I bis, Rome I, Rome II, service and evidence regulations, and of course, like you all know, the international conventions, like the Hague Conventions. One important point is that Spanish courts are fully integrated into the EU system and must apply the EU rules on jurisdiction. So all the courts in Spain can apply foreign law, the force directive cases. Another point is that Spain is a very procedural and documentation-heavy system. And that means that the civil proceedings put a lot of weight on formal steps, deadline, and written evidence. Spanish TP insurers very often draw with going to court without actually doing it. The claim is sent by their lawyer in order to speed up the payment process. We often receive here in Barcelona in the office demandas, which are court claims, but they are only sent in order to get a transaction out of court. Like you might know, the prescription of a claim in Spain is only 1 year and can be interrupted by burofax. If it's in a jurisdictional process, it's automatically interrupted. So, how is the court structure organized in Spain, applied to the cross-border cases? First, you have as an entry point the first instance, which is called the Juzgado de Primera Instancia. That is the court for most cross-border civil claims. The jurisdiction is determined by the residence of the defendant and the place of the damage and the insurance rules. Then you have the specialist court. like the juzgados de lo mercantil for the cross-border insolvency or company disputes. On appeal level, we have the Audiencia Provincial, which is handling appeals of cross-border cases from the first instance. So they derive from the first instance and they go to the Audiencia. And this reviews the facts and the application of the EU law. The main role is the correct application of the jurisdictional rules and the recognition of foreign elements. Then on regional level in Spain, there's the Tribunal Superior de Justicia, which has a limited role in civil cross-border matters, because it only exists mainly when there is regional civil law, when this civil law on regional level applies, like in Catalonia. Then you have the Supreme Court, the Tribunal Supremo. This court decides in cassation appeals, and it focuses on the interpretation of the Spanish law, and it assures uniformity. One thing I would like to add to this part are the key actors relevant in the cross-border cases. There is as main participant in the cross-border cases, the abogado, the lawyer, with his legal strategy and EU law arguments. Then you have the procurador, which is the procedural representation before the court. Then, of course, there are the experts on foreign law who give their opinion on the content, the legality, and the interpretation of the foreign law, together with the legal texts and the sworn translations. The evidence which is needed are the medical and the technical reports, the police reports, and the insurance files. So now that we have seen for a brief moment the legal framework, let's go back to the general rules upon reception of a claim in Spain. The insured must notify the claim within 7 days from knowledge of the loss, unless the policy allows, of course, longer. In motor liability claims, especially with third parties, the insurer must make a compensation offer or issue a reasoned reply, which can also be a motivated refusal. The time frame in Spain is 3 months to respond to an injured party's claim. The insurer must pay within 40 days from the notification of the claim, at least the minimum undispute amount. So even if liability is disputed, the partial payment may be required. And what is then the penalty if there is a delay? If the insurer fails to comply, the penalty interest applies, and it can increase seriously, like for till 20%. If the claim is not settled, what is then the course and the timeline of the civil proceedings in Spain? Well, there is first the pre-litigation phase. That is where exchange of offers and counter offers take place, and where there's a possible mediation or negotiation. And that means that the mask can come in. The mask is relatively new in Spain. It's from 2025. And it applies in cases more than 2,000 euros. Mask is the Spanish system for out-of-court dispute resolution, such as negotiations, mediation, or conciliation. The parties usually must try to resolve a dispute before starting the civil proceedings. They can do that directly or through the intervention of a neutral third party. The mask came then into force in 2025, just as well to reduce the heavy load on the court and the civil matters, and just as a cost reduction as well for the insurers. It's mandatory in civil matters to do first a mask procedure before legal proceedings can be initiated. So you have to prove that you did a mask before actually starting the legal proceedings. The most common forms of mask are mediation, conciliation, and direct negotiation with or without the assistance of a solicitor. Normally, it's enough that negotiations have been started, even if they do not lead to an agreement. If mask does not work, the claim can be filed before the Juzgado de Primera Instancia with facts, legal grounds, and full documentary evidence. The defendant, the insurer, has 20 working days to file the defense. In motor claims, the injured party can sue directly to the insurer, or to the insured, or to both jointly. So, first of all, you have the preliminary hearing in court with attempts to settlement, defining disputed issues, and admitting evidence. Then you have the trial with presentation of the witnesses. A brief explanation about witnesses in Spain. Any person who was at the scene of the accident and who saw what happened is a witness. And lately, so very recently, even the people being transported in the same car and pedestrians which are involved in the accident can be considered as witnesses. But they always need a witness statement of the traffic accident as well as a piece of identification. Then you have the presentation before the trial of the experts, and you have the documentary evidence. Normally, it is a typically short process. It takes 1 or 2 days. After that, you have the judgment. The court issues a written decision. Usually, this is 20 till 60 days after the trial. In case of appeals, the cross-border cases go to the appeal for its full review or to the Supreme Court for legal issues only. So, to give you a little resume of the typical duration, the pre-litigation is 2 till 8 weeks, more or less. The filing with the consequence, the hearing is 3 till 6 months. The trial with, after that, the judgment is 1 to 2 months, and the appeal can last 6 till 12 months. So in practical, the reality is that complex or cross-border cases can take 1 to 3 or even more years in total. What is interesting here are the costs, of course, of those proceedings in Spain. The main cost category are the lawyer, which is freely agreed and market-based on claim value, complexity, and duration. In general, small claims of more or less 10,000 euros, the fee of the lawyer would be between 1,500 and 3,000 euros. Then you have the procurador, who is the court representative, which is mandatory in most proceedings above 2,000 euros, and who handles the procedural filings in the court communications. The costs are regulated and generally are less than the lawyers. It's like 200 till 500 euros for small claims. Then there are the court fees, the tasas judiciales. Those are fixed fees set by law. Typically, it's 150 till 1,200, depending on the procedure, and around 300 euros for ordinary proceedings. Apart from that, there are the expert fees, the peritos in motor claims. Medical, technical experts are paid by the party requesting them, and costs are highly variable. And you have the additional costs, like the sworn translation, key in cross-border cases, notary, travel and evidence gathering. Who are paying for those costs? Well, in Spain, a general rule is the loser pays. If one party loses completely, they must pay their own legal cost and additionally the third-party costs. The exceptions are if the case raises serious legal or factual doubts, so each party then have to bear its own costs. How are the costs calculated? Well, after the judgment, the winning party submits a cost assessment, tasación de costas, and the court then reviews and adjusts the fees. Only the reasonable, the proportional costs are recoverable. What is the timing of the cost payments? During the proceedings, each party pays its own costs upfront, and after the judgment, costs can be recovered if awarded. The interest and delay penalties, which are very critical for insurers, those are separate from the procedural costs. Penalty interest may apply for delayed payments, and like I said before, this can go up till 20%. So in practice, cost exposure for claims cross-border who are going legal are quite expensive because you have to count on the legal fees, the interest, and the damages. So I came to the end of my part of the presentation. Thank you very much for your attention. I now leave the word to my German colleague, Georg.
Thank you, Rianne. Thank you, Martine, for your nice introduction. And hello, everybody. It's an honor for me to address the audience here. One previous information, the German courts are not bound by European regulations to the same extent as the Spanish courts. Therefore, I would like to inform you about some interesting insights of German procedural law that also applies to the cross-border claims as well as in a normal German lawsuit or action. We have four level of civil courts. The lowest one are the local courts. Local courts are responsible for lawsuits with a limit up to 10,000 euro. We have roughly 680 local courts all over Germany. Above those local courts, we have the regional courts. We call it Landgerichte in Germany. Landgerichte or regional courts are responsible for all lawsuits above 10,000 euro without any limit, even if it's a millions claim. Above this, we have the higher regional courts. We call it Oberlandesgerichte in Germany. They are mostly responsible for an appeal. And at the end, the federal court or Supreme Court responsible for the upper appeal we call in Germany Revision. It is important to know that court judgments are generally not binding for other courts. There are sometimes significant differences in case law, particularly among the local courts. In German, we say, to be on the high sea or at court, it's the same. You will never know what happens. As a general rule, the decision of the federal court, the Supreme Court, are mostly followed. Because the judge always, of course, tries to ensure that his decision will stand up to appeal. But when it's in contrast to the decision of a verdict of the Supreme Court, an appeal will normally be successful. What to do when a lawsuit is incoming? Also, as in Spain, we have a very short limitation to start a defense, but it's only 14 days in Germany. Calendar days. This can be a problem when, for example, the long Christmas holiday or some other public holidays falls into this time period, as well as the weekends. So we have just a few working days to decide what to do and to start the defense. Afterwards, there is mostly another 14 days period to provide the appropriate explanations, the grounds on which the lawsuit cannot succeed. All those letters from the lawyers are sent to the court. The court will forward it to the other party, and the other party has then the possibility to argue against the last letter of the lawyer who defends the interest of the people or the person who was sued. As soon all arguments are exchanged between the lawyers, always sent through the court, the judge will state a date for an oral hearing. The subject of the oral hearing can be negotiations between the lawyers, a witness questionnaire, or another taking of evidence. Important here because it's very different to other countries. In Germany, everybody can be a witness, with exception people who are sued. They cannot be a witness. But even my wife, my husband, my brother, sister sitting on the passenger seat can be a witness according to German rules. The judge will consider the statement always in accordance to plausibility and the validity of the statement. And if my family member was sitting on the passenger seat makes a trustful explanation, it can be a very important rule or very important explanation for a verdict or to influence the court in his decision about who's on fault or not. Besides this, the parties have also the possibility in the oral hearing to negotiate a settlement agreement. So it's normally a free conversation about every possibilities. This can be sometimes in accordance to the individual situation, a more economical thing to make a settlement agreement. But we have to be very carefully for it because the court and the lawyers as well have big interest to come to a settlement agreement because the lawyers get another fee for it. I will follow to the fees a little bit later on. And the court is very happy that he has not to write a verdict. Once I could follow a conversation between two judges in the cantina of our Cologne court, and the one was informing very proudly that he has a quota of 40% of settlement agreements, what means he can go home very early and has much less work. So we have to think about and to wait up if a settlement agreement is in the financial interest of our client. At the end of the oral hearing, the judge will state a date for a decision. This can be a second oral hearing or a third one, if there is a need or another taking of evidence necessary, or it can also be a verdict. Now to the cost of the action. Same as in Spain, the loser pays everything. If the court comes to a splitted liability, for example, the cost will be shared in accordance with the court's judgment. In case of an agreement, the costs are also subject and can vary. The lawyer fees, we are talking about, when we talk about costs, there are the lawyer fees and the court cost. The lawyer fees are as follows. The first fees are, we say in German, Verfahrensgebühr, applies as soon a lawyer is instructed to sue somebody. The fee includes as well the creating of the lawsuit and sending it to the court. A second fee applies with the participation on the oral hearing. In case of agreement, another fee applies, a third fee. That was I was talking about. Every lawyer is happy about a third fee. Besides this, we have the court fees. The court fees applies for the proceeding of the court. First fee applies when the court gets a lawsuit and forwarded to the other party. The second fee for the oral hearing, and the third one for any decision independent if it's a decision about the main subject or only the cost. Even in cross-border claims, the court fees increases very much. Why? I will go to some explanations later on, but court fees are very expensive in cross-border claims. The court cost also includes fees for experts, like in Spain, medical experts for accident reconstructions, something like this, translation costs, and of course, expenses of witnesses. Now I come over to some specifics of our cross-border claims. Just a short example, the German car driver goes to Norway, he is rear-ended by a Norwegian insured, he comes back with a claim to the rear of his car. Besides the repair amount, the lawyer makes hope to get as well fees for an expert report, depreciation, rental car, everything what's normal in Germany. But as most of us know, the Scandic rules does not provide lawyer fees or depreciation, only in case of exceptions. Now we have the fourth directive. Here, the courts are bounded to the European rules. Every damaged third party can start a lawsuit on his on the residence of his on the court of his residence. The fourth directive entitles third parties to sue, but only the foreign insurance company at the German court. But here the problem starts. The judge is confronted with foreign law, but he has no knowledge about it. What to do? In view of the very high cost risk we already think here about, if it's a better way to accept the lawsuit and to pay than to go through the action. The court, no knowledge about Norway law or some other law abroad, will instruct a specialist for the foreign law, and that can cost between 2,500 and 5,000 euro, independent the amount of the subject, even if we're just fighting about an amount of 800 euro. So here we think about it's not appropriate and a very high cost risk for nothing. When we do not succeed with our objections in accordance to the foreign law, we have also to overtake those very high expert fees, court cost. That means going through the action means to bear a very high cost risk. Unfortunately, there is no consistent case law across the local courts. Generally, due to the matter of liability, the court takes into consideration the rules of the country where the accident occurred. This makes sense, since the traffic law differs sometimes between the countries. Just think about the liability situation in a roundabout in Great Britain. It's very different than in other countries or in Germany, for example. But the situation is different regarding the amount of claim. In our example, the justification of expert fees, depreciation, rental car, lawyer fees, the court tends to confirm the damage in accordance with the German guidelines. We can see it in a lot of court verdicts. The courts take the view that the damage is realized in Germany, even the accident occurred abroad. However, this view is contradictory with the European institutions, which argue that a car driver cannot simply take the German law with him abroad in the backroom of his car. But nevertheless, here, especially the local courts, always or very often follows the German rules in accordance to the amount of claim. Unfortunately, there is a lack of higher court rulings on this matter, and especially on the many different national laws and the frequently disputed items of damage. This is because in most cases no appeals is lodged against the decision of the local courts in view of another very high court risk. At the end, the longer we are going through the action, the more expensive it will be. And this makes only sense if it is appropriate to the main subject. If we are fighting about a very high amount of 50,000 euro, we can think about to go through this cost risk, but not if we are just talking about depreciation or the fees of an expert. That's the reason why we, before we start the defense, are talking with our client that it would be better to accept the claim than to keep the very high cost risk of a legal action like this. So at the end, to settle a claim where the amount is in dispute is not particularly high makes more financial sense than running the risk of losing the case, which would also mean bearing the full cost. It's better to accept the lawsuit. Even if this leads to an unsatisfactory outcome, because the Scandic insurer is angry and says, I do not have to pay lawyer fees normally, but now we have to do. It's a better solution to avoid many costs. In case like this, we can only recommend to settle if the amount of lawsuit is not that significant. Thank you very much for listening. I think there are perhaps some more questions, and I know that Martine will give us some minutes more to provide you answers to questions raising up.
Yes. Thank you, Georg, and of course, Rianne, for sharing such valuable and interesting insights. In the meantime, we are open in the Q&A. I know there's much more you could tell us, of course, and that's today's session only could touch on a small part of the work you do. And of course, the expertise you and your teams have, but you have already shared a lot with us today. I can imagine there may be some questions. So therefore, please feel free to ask them in the Q&A. On the other hand, we have also noticed that our audience, or let's say our people, often have very specific questions and they do not feel very free to ask their question in a Q&A. So therefore, I would love to take this time also to ask people or invite people to send your question directly to us. Send your question via email. You can send your question, how small or how specific it is, doesn't matter, via email to marketing@vanameyde.com, and we will make sure that we will send it to Rianne or to Georg. And yeah, we will be very happy to get back to you. So if there's any question now, make sure you make use of the Q&A, and we would love to give an answer. We have some room, we have some time. And otherwise, again, if you have any question on any specific topic we touched on in this webinar, or if you say it is cross-border specific for Spain or Germany, please feel free to send your email to marketing@vanameyde.com, and we will make sure that we take some time to answer your question. We also see one and two people leaving. Yeah, I think the information was already very clear. So in this, I think we're going to finish up, Rianne, if that's okay for you, Georg, if that's okay, because there are no questions coming in. I would like to thank you. I would thank the audience for listening to us to come in this webinar. Would love to invite you for our next webinar. Please attend. We will tell you something about interim staffing and what's going on in the market. Thank you very much for being here. And of course, thank you very much, Rianne and Georg, for telling us all these insights, and would love to invite you for our next webinar. Thank you very much and have a great day.
Thank you.
Thank you very much.
Bye, everybody.
Bye.